if they just give me the money to do a pilot, right, I'd employ two family support workers to do this work in my town, for my local court centre, and it probably cost, under 100,000 a year. And if I could just divert one case that would otherwise end up in a fact-finding hearing and a final hearing, that would save more money than that. I want to speak mainly from my experience of helping families who've been navigating the family court system. And I speak as someone who their main practice area was in something other than family law. So I'm also able to draw some parallels with how other areas of the court system works and how they try to help people resolve their cases. And I've called this this presentation, How the Family Law System Can Do a Better Job for Children Whilst Money is Tight, for two reasons. The first is money is incredibly tight. We know that the Ministry of Justice was not protected in the way that some other government departments were during austerity, and that led to very severe cuts on the MOJ budget. And we know that this isn't going to change, that the pressures on public expenditure are growing, and that we can't expect justice to receive greater money, whoever wins the next general election. The other reason I chose this topic is because we know that the family law system is not doing a particularly good job for children. And I don't know if some of you listened to Sir Andrew McFarlane on the Today programme this morning, where he was very much setting that out and pointing out the impact that lack of resources has on both public law family proceedings, that's care proceedings, and also on private law proceedings, because both the local authorities and for parents, often they're finding that the lack of resources elsewhere in the state system is such that they end up coming to the court because no other services or no other appropriate services are available. I therefore think that we have to find solutions to those problems that don't cost more money and ideally save money, because otherwise we don't have any prospect of getting them adopted under whichever colour of government we have going forwards. Prior to setting out my suggestions as to how that might be done, I want to make some preliminary observations that should inform, I suggest, the approach that we adopt. The first is this concept of trauma-informed proceedings. And I very much agree with Professor Hunter that proceedings need to be conducted in a trauma-informed way. One of the things that judges are trained is that in all sorts of court proceedings, often many different kinds of parties are traumatized because of the pressure of the proceedings, because of what's at stake for them, because of their own personal experiences. And we certainly shouldn't minimize domestic abuse. And we also shouldn't minimize the impact that it has on people if they don't see their children for a prolonged period. If you want to drive people mad, take away their children, and you'll soon have a mad person. So all of that needs to inform the court's approach. Secondly, in relation to domestic abuse and safeguarding, I'm surprised that only 40% or 60% of cases have domestic abuse. And frankly, when you're looking at private law proceedings and looking at the wide definition of domestic abuse, probably 90% plus have elements of domestic abuse, sometimes from one parent, sometimes from the other parent, sometimes from both parents. And you also have cases where there's very concerning behavior from other relatives or even the child themselves. And that's why the cases are not capable of being resolved outside of court very often. And we need to recognize that there are no perfect parents, that yes, we have to prioritize safety of everyone involved, but we also ultimately have to answer the question as to what is in the child's best interests. And that doesn't depend on finding perfect parents. It depends on resolving problems and enabling the child to have a good relationship with both their parents and other wider family members, including, for example, grandparents, where that can safely be achieved. And it's certainly not the case that the family court prioritizes contact above all else. That's not the law, and it's not what's happening. In terms of possible solutions, the Pathfinder I'm very supportive of. Essentially, what this is, as Professor Hunter said, trying to find out as early as possible in the proceedings through the court system what is going on for this child, what's the actual dispute, can we actually identify what the issues are in this case and start resolving them, because otherwise you end up with huge delays at the beginning of the process, which are often quite avoidable and leads to the situation you're dealing with becoming much worse than what you originally started with. So I'm very much in favour of that. But it also has to be recognised that there are some elements of Pathfinder that are taking us back to how we used to do things before that were actually better. So to take, for example, the what's called a FHEDRA in family court proceedings, it stands for First Hearing Dispute Resolution Appointment. The name of it would suggest that what should happen at that hearing is that you have a judge sitting down with the parties and trying to work out what are the disputes that need to be resolved and how are you going to resolve them swiftly with an appropriate timetable. And often in the old days, where there was more time for the judge to look at the case at that stage, where perhaps the CAFCAS officer would have already gone out and spoken to the child, spoken to the parents, seen them at home, and also outside the doors of the court, the CAFCAS officer could sit down with the parents and try to find a resolution. You could sometimes get cases resolved at a very early stage, so that would be the end of it. But what's happened, especially since COVID, is that you have safeguarding checks carried out by CAFCAS officers who've perhaps had a 15-minute phone call with each of the parents and then produced a report. Often that safeguarding report has itself been delayed for a long time because of delays of other agencies providing things like police information about police involvement with the family. So all of that contributes to delay. Then you get to this FHEDRA in court, and sometimes they're listed not even in front of lay magistrates, but in front of the lay magistrate's legal advisor, who doesn't have any power to make any substantive orders. So you can see that that is really removing any real prospects for early resolution, and a judge to really sort of roll his or her sleeves up and try to get to grips with what's going on and how we're going to solve it. And the Pathfinder is very welcome in getting us a bit more towards that. But we have to recognize that these sorts of reforms in family law tend to go in circles. And actually what's needed is just that basic focus on identifying the problems and seeking a solution. In terms of how can we solve these problems while saving money, I've only got a few minutes, but I'll just group them under two main headings. The first is dealing with inefficiencies outside the family court system, and the second is inefficiencies inside the family court system. And in terms of outside the family court system, it seems to me that we do not invest in providing proper support for families in relation to any family issues in the community, and that often the only agencies that parents are able to access perhaps are domestic abuse services, and even they are in some places quite thinly resourced. But there's nowhere that you can go to and say, look, I'm breaking up with my husband or wife or boyfriend or whatever, we have a child together, we're not able to communicate effectively with each other, it's become very tense. Perhaps sometimes words have been said or actions have been said that could be classified as domestic abuse. Often that is very common in the context of a relationship breakdown where people are very upset and they need support. But that support to actually help them navigate that difficulty and communicate between the parents and try and work something out. That just isn't there. It's not being funded or supported in any way. And so you are ending up with people coming to court because they've exhausted all other options, because there aren't that many options to exhaust. And mediation is just not suitable for many of those situations where they actually need support with their family. Sometimes it may even be practical support. For example, if you want to assess how a parent who hasn't seen their child for a couple of months would get on with that child, maybe they do have to have some form of supervised contact, or perhaps they could spend some time with a family support worker with the child in some sort of early help type centre. But the funding for that just isn't there at the moment. And if it were there, if it could even stop a small number of these very difficult cases that end up in consuming a huge amount of family court resource, it would save a huge amount of public money. And then in terms of inefficiencies inside the family court system, clearly because of these many cases that require a lot of judicial work when they become very complex, the professional judges, that's district judges, circuit judges, their time tends to be deployed more towards dealing with those difficult cases. But that means there's less resource for the early work with the case. When it first comes in the door, triaging, resourcing the FHEDRA properly, or if you want to do it through the pathfinders, using those mechanisms in order to try to find a way forwards and shorten the time that it takes to get these cases to a resolution. So anything that does that, I think, will also assist greatly in saving money. And it's a false economy to take resource out from properly triaging cases. And also, we shouldn't forget that just because cases have come into court doesn't mean that there's no further scope for the parties to sort it out between themselves. That in other kinds of civil proceedings, judges will adjourn cases for mediation or other forms of alternative dispute resolution. But for some reason in family law, we seem to have got into a mindset where we're trying to divert people from coming to the door of the court. But once they do come into court, then the court has to basically take complete control over all the disagreement and resolve it from beginning to end. And that just doesn't make sense, because a lot of people who are diverted from court probably should come to court. And there are also people who've started off in court in a very tense family situation. And actually, once the issues have been identified and the court's done some work, it would be possible for them to resolve their issues with the help from outside agencies if the support was there. And a lot of parents come to court after they've tried engaging with social services and received no assistance whatsoever from social services. And there's also lots of parents who think that CAFCAS are going to come and do social work with them to improve this situation. And of course, that's not what CAFCAS is resourced to do. They just provide reports essentially for the court process. So I could go on a lot more in terms of solutions, but I think those are where the solutions lie. I do think there's a vast amount of public money that could be saved just within the family court system alone by doing those things. And all of that money could be ploughed back into doing work with families. And that would also save huge social and economic costs in the years ahead because of the harm that's done to the children and families from going through a process that isn't currently providing good and timely outcomes for them. As the last word I want to say, and then I'll stop, is there's so much awfulness about the debate to do with family court reform. There's ridiculous disputes about terminology, whether we should use terms like parental alienation or not. There's sort of men versus women battles, etc. But it seems to me that actually a lot can be agreed, as perhaps the extent to which much of what Professor Hunter said already, I think I would agree with, and many other people would agree with, that we need to look for common ground and stop having these sort of artificial battles that don't actually advance anything for the children and families.
Thank you very much indeed. So open to questions. Either start speaking or put your hand up. Sam.
Hi, Alan. Thanks for your time again. obviously the government responded. If there's a question about earlier resolution and trying to keep people out of court to some extent in order to, based on the level of resources, what was your kind of reaction to the government response to the earlier resolution consultation, which was on Friday, if you've had a chance to read it?
Yes, yeah. Well, I think that they are right in recognizing that mediation is not a panacea. Now, obviously, there are different kinds of mediation, and some may be more appropriate for cases with domestic abuse or higher conflict, etc. But parents are not going to be able to themselves identify mediation routes that may be appropriate for them. And actually, in the context of a really tense and upsetting family breakup, I mean, if any of you have been in a situation of a breakup of a serious relationship where you've got children with the other person, it's a massive thing. And if you're not seeing your children, it's a massive thing. And actually, parents need support through that process. And I hope that MOJ will, rather than just say, okay, well, compulsory mediation is not going to work, I hope they're actually going to look at putting resource in place to support. I mean, if they just give me the money to do a pilot, right, I'd employ 2 family support workers to do this work in my town, my local court centre, and it probably cost, under 100,000 a year. And if I could just divert one case that would otherwise end up in a fact-finding hearing and a final hearing, that would save more money than that for the public. And so it's just such a no-brainer in a time of austerity that we have to go down this path in a way that would save huge amounts of money.
Okay, any further questions? Catherine G.
So I was trying to work out how to electronically raise my hand. I haven't figured it out. Hi, Alan. I'm Catherine G. I'm a family barrister at Pump Court Chambers. Would you agree it's perhaps even more simple than that? And it's a question of education, really, and access to resources and information for people. Because one of the issues you have at the outset when people have to go and do their MIAM, which is a mediation information, I can never remember what it stands for, but it's a pre
information assessment meeting, I think
that's the one. Yes, thank you, well done. People don't like the idea of going to mediation, particularly when they are in a conflict situation where they sort of feel, well, I'm going to be made to compromise, or I'm going to have to listen to that person. And I think sometimes what people just need is information about what is this process going to look like? What do models of, how do separated families sometimes look? What can you do? And like you suggested, people's awareness that perhaps a supervised contact centre and that they can pay for it and these are the costings. Would it not be as simple as something like, well, it's going to be social services, isn't it? With something like an outreach of social services as well as early help. There could be, for example, a separated families unit, not necessarily taking up lots of resources with caseworkers as such, but even just a website with that information would be a great help. Would you agree?
I think a website would be a great help, but I think we need the support for families as well to go with it, because obviously some people are capable of looking at the information and then navigating things themselves, and others might have more difficulty. I mean, one thing that I find really interesting is to contrast how private law cases are managed with how public law cases are managed, because often, as you know, you have a case where the child's not seeing one of their parents or relationship breakdown, but for whatever reason, there's already been social work involvement with that family. The social workers do get involved. They have a family conference, they figure something out, and it ends up with a much better outcome that would have happened if there'd been no prior social work involvement with that family.
That's true. Although, I mean, I've seen cases where and it's usually in conflict cases or cases where there's domestic abuse. And as far as social services are concerned, provided the child's safe, they're not bothered that there's no contact. So there might be no contact, or they've perhaps advised usually the mother to withhold contact for some reason. And then, the father will contact social services and say, I'm not having contact with my children. And as far as they're concerned, that child's safe, and that's the extent of our involvement. It doesn't at the moment seem to be an active promotion of family cohesion or support for parents during separation. It simply is that child safe, and that's the limit of the remit of social services. I find there have been 1 or 2 excellent social workers that have gone above and beyond to sort things out, but they're rare. They're really rare and unusual. So do you think it might be an issue with social services that needs to be some level of reform around that?
Okay, we've got 1 minute.
Yes, I think there does, because I think you're right that often a parent will ring, usually the mother, social services or domestic abuse helpline or whatever, and say, this has happened. And as soon as any domestic abuse is identified, often the social worker will say you should stop contact, even if the person calling them doesn't want to. And so sometimes it can send things off down this path where you end up with very protracted proceedings, when actually perhaps supervised contact would be safe. Perhaps there's a way that the issues can be further explored to find out what the risk is to everybody involved. But it does all need resources. And I guess the case I'm making is the false economy, not to put them in.